I'm very happy to say a few words on this important piece of legislation on the amended directive on the rights, support and protection of victims of crime, which will, I believe, improve the current 2012 directive already in place. And I think it will respond in a more targeted and comprehensive way to victims of crime seeking to have their rights vindicated, particularly in another member state. And this includes procedural rights, the rights to receive a decision on compensation from the offender at the end of criminal proceedings. To me, this type of legislation is what I would call underpinning legislation, in that it underpins one of the four freedoms, the freedom of movement. There's no point in speaking about freedom of movement for people to travel, for work, for study, for retirement, for leisure, unless those people can rely on the protection of the laws of the country that they are now living in or that they are now visiting, and unless they can access public and other services in line with the same as citizens who reside in that country, and that the authorities in that country will vindicate their rights as EU citizens. Now, none of that would be possible, and it certainly wouldn't be workable if we didn't have this whole system of what I call EU underpinning legislation. And we have a lot of it, from the coordination of social security to recognising qualification rights. We have it from the European Health Insurance Card, which allows anyone travelling to access healthcare in another member state, to this directive that we are discussing here today. Now, we already have a victim rights directive in place, which lays down rights for all victims of crime, including the right to information and the right to support and protection based on the victim's individual needs. And as I said earlier, the right to receive a decision on compensation from the offender at the end of criminal proceedings. However, the directive that we are now working with is the 2012 directive. And since its implementation, the European Commission, as it does with a lot of pieces of legislation, often assess the impact of that legislation. They see how it's working. Does it actually achieve what it sets out to in the directive? And by doing this, they often identify shortcomings and they propose amended pieces of legislation. As you'll be aware, Minister, we have thousands of them at this stage. And in this particular piece of legislation, they did identify a number of shortcomings, particularly in regard to victims not receiving adequate or accessible information in regard to vulnerable victims, whether they were children or older people, or whether they were people with disabilities, victims of hate crime, victims in detention. And that the truth is, they don't always benefit from a timely assessment of their needs. There were also some issues around access to compensation and the lack of legal advice. So this directive now sets out to deal with some of those shortcomings. And not just that, it also sets out to integrate some other newer pieces of EU legislation since 2012, for example, the Directive on Combating Violence Against Women, the Directive on Sexual Abuse and Child Pornography, the Counter-Terrorism Directive, and a number of other directives. They set out to integrate those pieces of legislation into this newer directive. In other words, that it will take cognizance of them. Now, the legislation itself has been broadly welcomed by many groups. However, we do have an issue here in that we have a common law system, unlike most other member states. So that has implications for our justice system and indeed for our own citizens in our own country. The briefing note we received highlighted the three main issues: the issue of compensation. Does this in some way place an obligatory requirement on the judiciary to consider compensation? That's not how we do our business here normally, and there could be significant cost implications, and I believe there'll be a nice bit of work to be required on that. The idea of the provision of helplines, again, a number of groups supporting victims in particular have identified that just having a single helpline could be a significant barrier to those looking for assistance. And also the rights of victims to review decisions made about them in court process. Again, that could have significant implications on our legal system. I'll be interested, Minister, to hear what you have to say and how, and I believe you've already said we can largely accommodate those concerns, but of course the detail will be extremely important. Thank you.